Welcome to For the Record with Greenwood Law.
Welcome back to For the Record with Greenwood Law with attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level personalized representation and hands-on approach to every case. I'm Evan Mack, and today we're talking about what happens in the first 24 hours after an arrest in North Carolina. Dylan, sir, welcome back.
Thank you. Happy to be here.
Good stuff. So after the arrest, Dylan, when someone is arrested, how does that, 24-hour window typically unfold from the moment they're taken into custody?
So usually that's a really hectic period of time. You're going to get processed at a detention center. You're going to be given an opportunity usually to call somebody. And then from a legal standpoint, you are going to have a first appearance. So most counties try to get you in as quickly as humanly possible to have a first appearance. Sometimes first appearances can occur with a magistrate, but their ability to do that is getting chipped away by changes in law that have occurred here in North Carolina as it relates to the setting of bond. But a bond in general is going to be set of some sort. Now, we have taken away written promises and we've taken away some other stuff that normally we've had on the docket here to be able to have for a pretrial release. But some form of bond, whether it be an unsecured or a secure bond, is going to be set. And if it's an unsecured bond, then you're going to get processed and you're going to go right back out. Okay, you don't have to post anything. But if it's a secure bond, then you've got to post some sort of security to be able to get out. So it's either that entire amount of money that you're posting or a family member is posting, or it can be property. Those are very, very special type of bond surety. Or you're going to a bondsman or bondswoman, and they are posting it for you, and you're paying a fee, usually between 10 and 15%. For them to post that bond. And in that time period, so that's bond, and then you're also getting advised of your charges. You're getting advised of the possible penalties related to your charges. People always call me up and they're like, they're telling me I'm going to get X amount of time and this and that and whatever. And I'm like, no, that's not what you're actually facing. That's if your criminal history was entirely maxed out. You do the worst version of this crime, they have to tell you that that's the maximum that you could get. Like, for instance, DWIs, they hear that, 3 years in jail is what somebody's facing on a DWI. Technically, that's correct. For the very worst level of DWI you could possibly get, 3 years. That's what you're looking at. But more often than not, most of the DWIs that people get end up with some form of probation. And at most they're looking at is 24 hours in jail for a lot of them. Not all of them, but a lot of them.
So once a person is brought in, how does the booking process actually work? What information is being documented at that stage?
So it's a lot of demographic information. I mean, it's, your name, your address, age, sex, driver's license number, social security, everything about you possibly that they could find. Or they would need all that identifying information. They're taking pictures. They're taking fingerprints. Some cases require basically that there is you have to assert somebody's criminal history. You have to ascertain that before you can proceed. The reason why is because we used to just look at criminal convictions. Now we also look at an entire criminal history as well. So all of that stuff is brought in, looked at, and assessed. But the main information is all the demographic stuff, fingerprinting, pictures, and criminal history.
So at what point does the magistrate or judge get involved in what decisions are being made during that initial appearance?
So as long as a magistrate has the ability to set conditions of release, they get involved almost as soon as somebody's brought in to a detention center. And I mean, we turn people in all the time. So we hear that charges are being brought against somebody either because we've worked in an investigation or our client gets wind of it and they call us and we facilitate them getting turned in. And when that happens, we're talking to a magistrate almost right away. Like from the moment like our client is brought in jail, we're having that interaction with the magistrate to go ahead and set out, why certain conditions of release should be, why certain should not. And that can really affect not only the amount of someone's bond, but also all the other conditions surrounding your release, because a judge or a magistrate has the ability to put a lot of conditions on them, like not going certain places, not being around certain people. There's all sorts of stuff. Even in domestic violence cases, it can be ankle monitoring.
Wow.
So that is kind of what that looks like with a magistrate, and they're making the assessment on bond amount, type of bond, and all those pieces of information we talked about are being brought in on top of what a law enforcement official is saying about this case. On top of that, what the charge is. And there's like a chart that talks about recommended bond amounts for specific types or classes of charges, or whether it's a drug trafficking offense, or whether it's just a simple possession, or whether it's a felony or a misdemeanor. There's a chart for that. Now, if it's the type of scenario where a magistrate does not have the ability to set a bond, or there has to be a hold on somebody until a magistrate sets a bond. So like in a domestic violence case, there's a 48-hour hold that states that a person should go to a district court judge within 48 hours of being picked up on a domestic violence situation. If not, if they cannot, then a magistrate gets to set the release conditions. And then we also have rules right now that have more recently come into place that if you're on some sort of pretrial release for another case, a district court judge has to set your bond within a certain amount of time. And if not, then a magistrate gets to. And so, a lot of people get picked up at night so that they can get on the next day's first appearance docket if we know that they have to go in front of a district court judge to set those conditions of release.
How is bond determined so early in the case? What factors tend to influence whether someone is released or if someone is held?
Yeah, so it comes down to a lot of times what the charges are, some sort of brief factual recitation by the state or by a law enforcement official. So those are two biggies. But what a judge or a magistrate is looking at, they're looking at safety of the community. And that's from a very individual perspective, but it's also to the broader community.
Right.
And they're also looking at, are you going to come to court? And so your prior record really matters.
Yeah.
And so it isn't just prior convictions anymore. North Carolina has broadened this out to look at your entire prior record. And so if you have some prior failure to appear or an order for arrest because you've missed court, that's going to make it look like to a judge that you have a problem coming to court. Another thing that they're going to look at is, are you out already for something else and you've recommitted, you've done another crime?
Wow.
That's going to be a scenario where it's going to be a lot harder to get a bond set or a lower bond. And then the other thing now that we're doing here in North Carolina is looking at violent crime. That's been a very recent change in the law as well.
So what role do early reports and charging decisions, play in shaping how these cases start to move forward?
So they shape them quite a bit because those are the initial facts that a judge has to go on to determine what a bond might look like, because you don't just put everybody into a box. You don't say, hey, you've got a Class H felony, you're definitely going to get a $2,000 bond. It's not like that. Every case is different, and that is the truth. I mean, every case really is different. So it's really important to get some facts from a judge's perspective as to what's going on. Now, the flip side of that is if we get in early enough and we can provide maybe a little clarity to those facts or an alternative way to looking at them, or we've got maybe some evidence contrary to what they're talking about that really hits at the veracity of their evidence or the ability to rely on it as much, then that can really help bond or shape bond to where maybe it's unsecured or maybe it's a really, really low secured bond. The other thing is, do you have stable employment? Do you have children? Is your family around here? Are they showing up with you to court? And then also, have you hired an attorney? That shows a certain willingness to be involved in a case, especially because we're in there trying to figure out exactly what's happened very early on and look at those facts and try to hit at them and really, is there a way to undercut those or to explain them?
So Dylan, during those first hours, how does the law enforcement continue building the case, and how do interactions or statements during that time come into play later?
Well, if you are in custody, you just need to be quiet. Okay. I can't tell you how many people have been waiting around getting processed and they get mad at what's going on and they just start saying stuff. It would potentially be a voluntary statement at that point. And then all of a sudden they've said something to hurt their case, or they get another charge. I've seen that spiral out of control where somebody just, again, they get mad. They say a bunch of stuff to the officer. Maybe they communicate threats. Maybe it ends up being a situation where it's a resist. Maybe it's perceived as an assault on a government official. You can also have a felony version of that for malicious conduct by a prisoner. It's a Class F felony. And that happens a lot of times when somebody is brought into custody, they get mad and they spit at a cop. That's Class F felony. So all of a sudden, you've taken your situation, you've just spiraled it out of control. But the main thing to really be keyed in on is just be quiet. Because, again, anything you can that you say can and will be used against you. And if you're not being directly interrogated by a police officer, then those statements might be considered to be voluntary. Now, if you're in custody and an officer starts asking you questions about your case and you've not been advised of your Miranda rights, that absolutely could be considered to be a violation of your constitutional rights. Because if they're asking you questions about the case while you're, while you're in custody, that's an interrogation style proceeding, and you've got to be advised of your Miranda rights in that situation.
So what tends to happen, with evidence at this stage, particularly in terms of how it's, collected, preserved, or evaluated in your experience?
Just assume that everything is being observed. So what you say as you're getting arrested, how you conduct yourself, whether you're polite, whether you're cooperative, whether you're not, every bit of that is going to be documented, either because a police officer has Axon body camera footage or because they're writing it up in the report, or both. So that can really matter, and it can really turn a not great situation into a really horrendous situation if you don't conduct yourself well. You're much better off, in general, you're probably not going to dissuade a police officer from serving a warrant on you if there's a warrant that's been issued. So you're better off at that point being cooperative, but being quiet than, resisting and saying a bunch of stuff and saying stuff to the officers and, again, compounding the situation. So just assume that everything is being observed.
So how do these early decisions, the bond charges, the initial reports, start influencing the direction the case takes, after the first day?
Yeah, so that starts affecting really our initial theories of what's going on and how we conduct our investigations from that point. Is it some sort of mistake or accident? Is there a way that we can explain that? Do we need records? I've had cases that looked terrible on paper. And I had one where it was a felony drug case, and my client got a assault on a government official charge, a resist, and a bunch of other stuff on top of it. She comes into my office, explains the situation, and she was like, "This didn't go down this way." I was hip checked by this officer, and this was a very small individual. And I was like, "Okay." She was like, "Well, it happened at a gas station." I was like, "All right. Well, gas stations, other private places, they usually don't keep surveillance camera footage very long. So if I know that early enough, then I can go seek it." So we drove up there. I drove up there, and I was like, "Do you still have this camera footage?" Sure enough, they did. Let me tell you right now, that turned that case entirely around. Now, there was nothing we could do about the drugs. We ended up getting her a lot of help. She cleaned up. That all went away via another path. But what we ended up discovering on the surveillance camera footage was that this officer had ripped this girl out of the car and had tackled her to the ground in an asphalt parking lot and then drug her by her feet across the parking lot and left her in the middle of a dark parking lot, like writhing in pain. And you could see every bit of this.
Wow.
And all of a sudden, it went from like all these stacked felonies, misdemeanors that had nothing to do with drugs. Every bit of that went away.
God.
And then, like I said, we were able to get her help for the actual issue. And then the other things got settled and handled elsewhere.
Wow,
But
wow.
yeah,
That's pretty amazing, actually. That's pretty amazing. For someone trying to understand the seriousness of their situation early on, especially for things like that, what details from that first 24 hours usually matter most, as these kind of cases develop?
just anything to know about the case. I mean, that again, like where it happened, how it happened, how did you get picked up, what might have led up to this, was there any, is there something with camera footage or whatever else? I mean, that any potential alibi, I mean, all those stuff, those are things that you're just kind of ticking off through your head. Can it be an explanation? Because if you can get a hold of that stuff quickly, then let's say somebody has got like a high bond to begin with, you get those pieces of information quickly, you go to a DA and you say, "Hey, I think y'all are mistaken. Look at this. Let's get our guy or our person out. And then we can figure this case out once they've gotten out. Maybe they can help get us more records, or they can help with their defense a little bit more, or maybe even sit down with police and explain something where actually, someone else was involved, not them. I mean, it can really pan out in a lot of different ways, but really just as much information about the who, what, when, where, why kind of questions as possible, so that we can get involved and know what's going on.
Dylan, good stuff. Thanks for your time, brother.
Yeah, thank you.
That's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thank you so much for listening. Don't forget to like, leave a review, and subscribe to the show so you do not miss the next episode. Thank you so much, and we will see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.